Andy touched on the topic of sham peer review briefly. And one of the first things I want to make clear is that I fully support good faith peer review, and AAPS supports peer review done in good faith. The only type that we're really strongly opposed to is that type of peer review that's done in bad faith for purposes not in the furtherance of quality healthcare. All peer review is not sham peer review. And so what does good faith peer review look like? Well, it should be collegial, educational, fair, done for the purpose of improving quality care and protecting patients, and it should incorporate substantive due process and fundamental fairness for the physician under review. So in AAPS, our physicians are probably the most knowledgeable about sham peer review of any medical association in the nation. And our physicians understand what sham peer review is. It basically represents abuse of the peer review process to, quote, get the doctor removed from the hospital and perhaps ruin or end the doctor's career. This is the legalistic definition, if you will, of sham peer review. It is an adverse action taken in bad faith by a professional review body for some purpose other than the furtherance of quality health care, and that is disguised to look like legitimate peer review. And you will notice that the last part of the definition here incorporates sort of the concept of fraud. In other words, they're trying to make it look like it's a legitimate peer review when it really isn't. And there are tactics that we've been able to identify that are characteristic of sham peer review. And we have published these tactics and updated them in our journal. And you can go to our journal and look at those to see what they are. They've been very useful and helpful in identifying tactics and basically unmasking them in some of these cases that go to trial. So there's a whole host of different types of attacks hospitals launch against physicians. There's sort of the pre-sham peer review attack, which is something that you might see at a morbidity and mortality conference where a doctor's cases are being singled out, unusually singled out for unusual criticisms or conduct. The thing that does not yet make this sham peer review is the fact that no adverse action has been taken against the physician at that point. And I define an adverse action as any type of action by the hospital that harms the physician. Another type of attack, of course, is an actual sham peer review attack, which involves formal peer review proceeding, often based on false, trumped up, or totally fabricated charges. And the last type, which is a severe and shocking form of attack, can involve physical attacks. And these are physical attacks intended to harm or kill the affecting physicians and patients. And you can read about two of these that are most shocking. They're published in our journal: Retaliation Against Physician Whistleblower, the shocking case of Dr. Michael Fitzgibbons, and Sham Peer Review, the shocking story of Dr. Raymond A. Long. In the case of Dr. Michael Fitzgibbons, it was revealed in sworn testimony by the president of the hospital that the CEO of the hospital had hired someone that was either mafia or mafia affiliated to get the doctor. And they also slashed his tires and caused a rollover accident, which could have injured or killed the actual drivers of his vehicle, which were his daughter was driving with two foreign exchange students from Japan, and it was a rollover accident, could have ended very badly. And then the case of Raymond Long, where they tried to apparently accuse him of having a post-op infection rate that was too high, when they couldn't do that because he didn't have any post-op infections. Post-op infections were created for him by someone at the hospital, deliberately injecting 3 different types of bacteria into the irrigation fluids he was using during surgery. And that caused several of his elderly patients to be ill and could have killed them. One of the things that illustrates is that hospitals often have no reluctance to using patients as pawns to get the doctor. So one of the things you need to recognize are the early warning signs of sham peer review and take appropriate action to be prepared. And these early warning signs have also been published in our journal. And you'll also find an article called Sham Peer Review, Disaster Preparedness and Defense. If it looks like a sham peer review is coming down the line at you, you need to understand those things you need to do to prepare, things you need to do, and things you need to avoid doing. You certainly, number one, before any of this ever starts, is you need to know your rights. You need to get out your medical staff bylaws and read them, particularly the corrective action section of the bylaws and the section involving summary suspensions. You need to choose an experienced attorney. And the way you do that most often is asking other physicians of victims of sham peer review. And you can also ask AAPS, as we have worked with a number of attorneys who are knowledgeable in this area and might be located in the area where the doctor's located. You also need to think about choosing 3 experts in your specialty. Write down their contact information, familiarize yourself with their work, and if you need these physicians in the future because you're accused of practicing beneath the standard of care, you want to have that information ready to go. And you also need to basically have what's called political preparedness. You need to understand that sham peer review is about politics and abuse of power. You need to always be aware of your political surroundings, political alliances in the hospital, and various turf battles that may be occurring. So what about physician whistleblowers? Well, physician whistleblowers are often a target of sham peer review because, believe it or not, hospital administrators often don't want to hear about quality of care issues or patient safety issues in their hospital. Instead of taking corrective action to remedy those deficiencies, sometimes they act to sort of kill the messenger, and they use sham peer review often to do that. So one of the first tips is don't go it alone. Don't be the sole person out there making these various criticisms because that puts you right at the top of the list with a target on your back. And so don't go it alone. Try and involve other colleagues in these concerns about quality care and patient safety. You have an ethical duty to try and protect patients in the hospital. So I'm saying, yes, try and get these things remedied, but don't try and do it alone. You also need to document. So in terms of written complaints or written letters about patient safety issues, you need to make sure that's in writing and well documented. And you also might want to consider consulting an attorney who may be able to file a complaint with an outside regulatory agency on behalf of a group of physicians while maintaining anonymity for the members of the group. Just a few words about the Purge. I think Andy mentioned this in passing, that there has been a nationwide agenda, more or less, by hospitals to purge independent physicians in favor of making physicians physician employees whom they have much more control over. And as you're aware, there's been a dramatic shift in at least the past 16 years from independent physicians practicing hospitals to hospital employed physicians. In 2018, 36% received compensation directly from the hospital as hospital employed physicians or indirectly, and less than 1/3 of physicians remain in independent practice, the lowest percent recorded since the Merritt-Hawkins survey was first conducted in 2012, and it's undoubtedly worse at this point. So what methods are being used to accomplish this purge? As I mentioned, sham peer review, creating a hostile work environment for the independent physician, financial attacks on the independent physician, and other more aggressive attacks, as I have mentioned. So what is creating a hostile work environment for independent physicians? Well, constant scrutiny of 100% of the physician's cases, looking for something that could be used against the physician, constantly imposing more and more unwarranted requirements on the independent physician, making the physician attend communication courses, engage in coaching, medical documentation courses, be subject to 360 surveys and various unjustified competency evaluations. There's also, of course, putting the subject of the physician whistleblower's complaint in charge of the whistleblower physician's ER call, operating room call schedule, for instance. And the one that comes to mind there was an anesthesiologist who felt that it was a patient safety issue because one of her colleagues was falling asleep during surgery. So you had an anesthesiologist that was actually falling asleep while the patient was, getting anesthesia. The doctor felt that was a real significant safety issue. It was not corrected by the hospital, but the hospital did then immediately put that physician in charge of that doctor's call schedule. And of course, as you might imagine, it was very bad for the doctor. And then there's a tax on independent physicians' autonomy by implementing, for example, co-management policies whereby less qualified physicians are allowed to overrule the attending specialist physician in determining prognosis and treatment decisions for patients. And a case there that comes to mind was a neurosurgeon who was basically forced into or coerced into a co-management policy whereby the hospital felt he was being too optimistic about the prospects and prognosis of his recovering patients. And they thought that was wrong to be so optimistic. And so they wanted to make sure there was a co-management policy whereby others, physicians who were not neurosurgeons, had significant say in what happened to the physician. And as part of that co-management policy, the physician was forbidden from talking with his own patients or patient families. So one of the things that happened in that case, and by the way, this was a publicly owned hospital, it was not a private corporation. And it was always my understanding that in publicly owned hospitals, the Constitution applies, including free speech. Free speech, as you may or may not know, does not necessarily apply to private hospitals. So in this publicly owned hospital, one of his family came in on a patient who he had just done surgery on. They came into his office and wanted to discuss how their family member was doing and what was going to occur, what the prospects were, and he talked with them in his own office. He got in trouble for that, and they used that as a contributing factor in taking away his privileges. So he exercised basically his right to talk with his own patients and his own patient families, and it was punished for that. And then, of course, there are what I call financial attacks on independent physicians, establishing a policy, for instance, whereby only hospital-employed hospitalists would be allowed to admit and treat patients in the hospital, reducing OR time slots in favor of, again, hospital-favored or employed physicians, reducing ER call schedules for the independent physician, eliminating independent physicians from rotating schedule for reading tests. For example, independent cardiologists may no longer be allowed to read EKGs, and only the EKGs were only being read by hospital-owned cardiology group, and shifting referrals from the independent physician to the hospital-employed or favored physicians. And sometimes this is done by actual hospital policy or by using hospital employees to spread negative rumors about the independent physician, gossip, innuendo, and so forth. So let's talk a little bit about the disruptive physician concept. This is still an active concept and one that's being used by hospitals to attack physicians. And it, of course, comes from the Joint Commission. And the Joint Commission, as you may or may not know, was established way back in 1951 by the AMA, the American Hospital Association, the American College of Physicians, and the Canadian Medical Association. It is, of course, the main entity that accredits hospitals nationwide. Some hospitals can elect to be accredited by their Department of Health, but most elect to be accredited by the Joint Commission and follow their standards. So what we have in hospitals is basically a labeling process. which ends up as a process for controlling physicians. And so I will call your attention to the right of the screen there. Hospitals basically lobbied the Joint Commission to get something called a code of conduct, which includes the disruptive physician conduct. And the Joint Commission then imposed that standard on hospitals. So hospitals said, oh, well, we don't have any choice. We have to implement and make sure this standard, code of conduct standard and policy is implemented, because that's what the Joint Commission says that we have to do. Of course, they lobbied the Joint Commission to get that. And you will also see other entities involved in this labeling process. There are P.U.L.S.E surveys, which I'll talk a little bit about later. There is computerized profiling that is now being used in many hospitals. Some hospitals have hired a full-time physician investigator. There are also companies which specialize in disruptive physician investigations that are being used by hospitals. And of course, there are seminars offered by the hospital bar multiple times per year in nice resort communities that basically help physicians to understand how to conduct a sham peer review while preserving their immunity. And they have a lot of immunity. Hospitals and peer reviewers have a lot of immunity under the Healthcare Quality Improvement Act of 1986, which basically considers physicians guilty unless and until proven innocent by a preponderance of the evidence. And the outcome of the labeling process here involving disruptive physician typically can result in referral to a specialized treatment center. Believe it or not, there are treatment centers that specialize in treating disruptive physicians. It's a very lucrative business. And it can also end in termination of privileges and ruin and end of the doctor's medical career. So in the summer of 2008, the Joint Commission issued a sentinel event alert. And a sentinel event is an unexpected occurrence involving death or serious physical or psychological injury or risk thereof. And basically what they said was that rude language and hostile behavior among healthcare professionals goes beyond being unpleasant and poses a serious threat to patient safety and the overall quality of care. So that disruptive physician standard basically went into effect on January 1st, 2009. Just a brief comment. Not all physicians who are labeled disruptive physician are falsely labeled. There are some actual disruptive physicians out there who maybe throw knives in the or scalpels in the OR or physically threaten others who are truly disruptive, and something needs to be remedied in those cases. What I'm talking about is the unjustified and false labeling of a physician as disruptive. And on July 1st, 2012, the Joint Commission clarified this leadership standard, which was 0.03, 0.01, 0.01, for those of you who want to look it up. And they revised the description of disruptive physician, removed the term, and replaced it with behavior and behaviors that undermine a culture of safety. So they're always trying to tie it to, patient safety. And this is the disruptive physician profile as taught by certain prominent law firms that give seminars on peer review. And this is the disruptive physician profile, which I have paraphrased a few things, but certainly a whistleblower would be considered disruptive. Economic competitor, they consider disruptive. Politically incorrect. A physician who is a strong advocate for quality care is disruptive. They're often described in this profile as charismatic, energetic, creative, and charming. An independent thinker, one who fails to submit to hospital authority, is often portrayed as disruptive. A highly competent physician, and you'll see this portrayed as, quote, always right. He thinks he's always right, is another one. Makes rounds at odd times, that somehow makes the physician disruptive. And there's also inappropriate nonverbal behavior, which is part of that Joint Commission standard and that I previously mentioned. And this can include such things as facial expression, body language, and tone of voice. And those are very vague, highly subjective things, as you might imagine. And then the last one is one of my favorites, defends himself vigorously when attacked. Now consider this. If you are falsely labeled as disruptive and falsely accused, why would that physician not defend himself vigorously? And again, there's legal seminars taught, and this is big business, really. Then there's the P.U.L.S.E survey, which some of you may or may not have heard about. It's also referred to as a 360 survey. And the P.U.L.S.E survey stands for Physicians Universal Leadership and Skills Enhancement. And this is basically, and these surveys are administered typically electronically on computers, and the results are color-coded as acceptable, borderline, or unacceptable behavior. It is a way of looking to objectify things that are totally subjective opinions about the physician. And one of the tactics that is used by some hospitals is using a P.U.L.S.E survey against a single physician. Typically, these type of 360 surveys are administered to all the physicians in the hospital or all of the physicians in a particular department. There's not one that's singled out. When the hospital singles out a single physician for one of these P.U.L.S.E surveys, the people who are filling out these surveys, of course, are going to think, wow, there's something wrong with this person. Why else would they be asking us specifically about that specific physician's conduct and behavior? And as I said, we're still seeing a lot of disruptive physician charges. It is absolutely the perfect accusations for hospitals to use, as no evidence other than how the accuser feels is needed. It's highly subjective. And the other thing that we typically see with disruptive physician is this. Oftentimes, a hospital may start out questioning and charging the doctor with quality of care problems, treating a patient below the standard of care. And when that case starts to fall apart, they will quickly switch to something more subjective, like the disruptive physician charge. So watch for that one. When the hospital's case starts falling apart, that's often what they will result to. So let's talk about fighting back. Number one, you need to be aware of your surroundings. These things don't happen in a vacuum. As I said, they happen in politically charged arenas where there's turf battles, personal animus, jealousy, a lot of things going on. You also need to just take prudent steps that anyone should take. Lock your doors, house and car. Check your tires. As I said, we've encountered at least 4 cases I've known where a box cutter was put into tires, broken off, and when that's done, the tire doesn't immediately go flat. It will, however, likely catastrophically fail when the doctor or whoever's driving the doctor's vehicle takes it out on an interstate or throughway going 70 miles an hour. And then they just say, well, too bad, the doctor had an unfortunate accident and died. So check your tires. Sometimes this is done on the inner wall of the tires where it's not easy to see. You need to retain an attorney early on who is knowledgeable with respect to sham peer review. I can't emphasize this enough. There are a number of health law attorneys out there who primarily work for hospitals, and some have no knowledge of or experience with sham peer review whatsoever. And where it is legal to do so, and I would emphasize legal to do so, you might consider carrying a concealed recorder with you at all times, such as the DB9 Pro. This is very helpful in some cases because people who are involved in promulgating or supporting these sham peer reviews often say things that you really wish you had a recording of. And in one case, a physician who was a victim of sham peer review recorded a conversation with the president of the medical staff, who told him that all of this was totally bogus and there was no merit to it, but he couldn't do anything about it because the hospital was pressuring him to go along with it. When they played that tape in front of a jury, it was case over. A few words about National Practitioner Data Bank adverse reports. Some attorneys who are not experienced in the area of sham peer review sometimes tell their clients not to worry about an adverse action report because the data bank allows physicians to submit a rebuttal statement which will be included in the report. While that's true, it does not undo the damage whatsoever of the data bank report. And again, there are some attorneys that think, well, if we can just negotiate better wording in the report, it'll be okay. It won't be okay. The mere existence of an adverse action report is like a scarlet letter. It's a red flag that other hospitals will look at and not want to put you on medical staff or hire you. And some attorneys who are not experienced in the area of sham peer review may even attempt to, as I said, negotiate the narrative. And it's just not helpful to their client. So at AAPS, we have your back. As part of our free membership benefits, we have the AAPS free limited legal consultation service, which is run by the nation's top attorney in sham peer review and medical board issues, Andy Schlafly. And we also have the AAPS sham peer review hotline, which I run on a pro bono basis. And, you know, between Andy and I think we have a fair amount of expertise in this area, which can be used to help physicians. So the key concept is call early on. Couple of quick case studies, or maybe just one since we're running a little long on time. 36-year-old solo practice physician has complained about quality of care and patient safety concerns at the hospital. The hospital officials have decided to take action to silence the physician whistleblower as opposed to taking actions to correct the deficiencies. False and trumped up charges are brought against the physician and formal peer review action is initiated. The hospital has stacked the peer review panel with physicians they can count on to vote for revocation of the whistleblower's privileges. And the hospital leaders and officials have told the physician, it'll go better for you and you won't have to go through all this unpleasant peer review if you just resign. What should the physician do? Well, I will tell you what the physician should not do. A physician in this situation often sees that everything's stacked against them, not going to get a fair hearing, and there's no hope for prevailing. And so they might think, well, I'm out of here. You know, I'm going to resign. I'm out of here. Hospitals like it when you do that, because as soon as you resign, they get to report you to the National Practitioner Data Bank, which again, they can ruin or end your career. And number two, they don't have to provide you with any due process, so-called fair hearing or appeals process, because you're no longer a member of the medical staff. So when things look like they're stacked against you, don't resign, get a good attorney, go through the process, make sure you have an independent record of the peer review hearing and appeals. That means a court reporter, even if you have to pay for the court reporter yourself, because that independent record might be used in litigation later. I'm going to skip this one again because we're a bit long on time. And I just want to make just a few final comments about sham peer review and physician suicide. This is a real risk because once a physician has gone through a sham peer review, is reported to the data bank or something similar, and career and reputation are ruined or ended, a lot of physicians develop depression. The depression can be severe and can lead to hopelessness and helplessness. And recently, I was made aware of a young physician, an obstetrician, who committed suicide. They accused him of using suction on deliveries more often than forceps, and that the suctions could result in hematomas between the scalp and the skull, which are basically of no clinical significance and resolve over time. And they totally ruined his reputation and ability to practice independently. They restricted him in normal deliveries to having a supervising physician there with him. And if he couldn't do that, he would not be allowed to deliver children. And so He committed suicide recently, left behind a wife and 3 young children. It's a terrible tragedy. And if you know of people who are victims of sham peer review in your community, be a friend. Listen to them, help them. If you see that things are not going well for them, try and suggest that maybe they speak with someone professionally to try and stop and prevent physician suicide. So I want to thank all of you for your support. Without AAPS and your support, we could not do all of the things that we do, and we're very grateful and thankful for your support. Thank you.